marks upon the beloved truth of value and wisdom reflection of the truth of the expression beloved to all self. The state of Washington responded versus Lorenzo Maurice Davis, Jr. Appellate number 60147-4-1. Court of Appeals of Washington Division 1 filed April 21st, 2008. Counsel for Appellate, Washington. Lorenzo Davis appeals his conviction for possession of cocaine. He contends there was insufficient evidence that the substance he possessed was cocaine, but the state presented evidence that during a search incident to arrest, police recovered suspected rock cocaine from a shoe Davis was wearing. A forensic scientist later tested the substance and found it contained cocaine. This evidence was sufficient to establish beyond a reasonable doubt that Davis possessed cocaine. Hello, my name is Lorenzo Maurice Davis, the defendant, and the state has a substantial element to prove that criminal indictments are relevant to the opinion. Published convictions result in evidence, a political statement that demands salvation to respect this freedom of truth, to serve a remedy that expands the agreement between mistake as suspicion and constitutional error as admissible proof of the judgment. Information discovers law-abiding authority. 1 is the subject that uses civil tort to manifest principles of decency, justice, and reason as personal weight upon the jury and upon the act in question. However, this is contrary to the trust created within the truth. We are not the visualization of the proof and opportunity. We are merely agents of the intent, not the united state of innocence, but rather a credible service secured in the original meaning articulated within the legislation that incorporates admissible restoration of the fact. 2. This theory warrants an immediate counter-argument to the contract that has been annulled by facts made in reality, led in ideas and concluded in time. Their statutory limits cannot muster a more sufficient basis to theoretical ground. The circumstances in an innuendo that requires immensity of legal consent. This domain returns to a problematic state of guilt, in one sense because it violates constitutional principles of trust, accepted as negotiable to an element of doubt, mistakenly erroneous to rationality and traditional courts of justice. For example, privacy adopts all the law to accept, security adopts all the right to neglect, and responsibility faces the tortuous prima facie merit, proving doubt beyond all reason, and consequently by inconceivable, unconscionable mistake, rejects appropriate approval to not reason the order essential union that offers a remedial mediation of the tentative intent to weigh evidence based on reality and false standards as critical. 3, to the power that produces a scientific account, a redefining matter to be the relevance that results in the established claim, whatever intent possesses, is the understanding of unfair treatment. This, the contradiction between that of the state and that link to complete the charge, is a foundation that acknowledges the story more than the custody. Being changed by society acknowledges the custom that the Seattle Police Department erred in misuse of the cause, not the probable value. I affirm the probative excuse beyond truth that suspects a subject of ground. To address my pro se statement of additional form, to value all energy void of preponderance and visually imperative to visitation, that jurisdiction is met by extradition. A law and reasonable view to impeach the officers who breach their criminal defense by reversing the concurrence of term, statute, and opinion solely to obtain hearsay evidence, illegally reported as economy and social excessive exchange between the secured and the unduly liable effect of arrest. Disproven reason upon doubt, beyond reasonable realities of doubt, while remaining forceful into their elements, that is, the statements of their inquiries into civil arrest, based upon the promise of freedom of information and of active deliberative thinking. Davis simply communicated silence, and this is evident based upon the truth of the disclosure. He needed, but he obeyed the plausibility of open authority more than the probable cause of negligent, torturous reunion. A defense will bring to light in the ozone witness that this concurrence reflects a more honest picture of the image once assumed to deflect intention upon law, not law upon an aroma avoidance. For this reason, I dissent to the limitation of the statute, or for that expedient thought, I contend the error of a fact itself proves the error in law itself. By Lorenzo Maurice Davis.